Let's all stand and pledge allegiance.
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Okay, everybody that wants to testify, please remain and be sworn in.
If you're going to speak, if you'll stand and raise your right hand, please. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Does anyone have any revisions, corrections to the minutes from last month's meeting, or a motion to accept them?
Move to adopt as presented.
I'll second.
All in favor?
Aye.
Motion carries. Okay, do we have any revisions to this month's agenda?
Under request for notice of assessment, item D, case 15 CE 5707. The property owner is here. The tenant will be here at 2:30. If we could move that to the end of the meeting to be heard.
Okay. Is that it? Okay. Since there aren't any revisions, we're good, right?
The agenda as amended.
Move to adopt as amended.
Second. All in favor?
Aye.
Aye. Motion carried. Okay, we'll start with a citation appeal, case number 15-CE-5512.
Case first.
Charles Kent, Gabriela Wagner.
I believe in this, the alleged violator is going to seek an interpretation of the code sections involved in the citation, is what I was advised.
Stand up and be sworn.
Exactly, yeah.
No, he doesn't need to be sworn.
No, I'm not testifying. Yes, I am Matthew Groom from law firm Rooney & Rooney, representing the Wagners, who are the cited individuals. We are requesting pursuant to 2-303, we challenge the applicability and interpretation of the cited ordinance.
This is one of those where they'll need to file the written appeal of the interpretation, and so the board would just need to postpone this hearing.
Okay, so
You want to just hold this in abeyance, is what you're saying?
Just postpone this hearing.
Postpone.
Yes.
Question. How long do these postponements go on? How long can they go on?
Until the appeal on the interpretation of the code is finally determined. That could go all the way to the circuit court and beyond.
Thank you.
I'll make a motion that we postpone this hearing until the appeal process is completed. Second. Moved and seconded. All in favor?
Aye.
Aye. Motion carries. Thank you.
Thank you.
Okay. Case number 15-CE-5602, JT and Jordan Wakeland.
Requesting a notice of assessment for case 15 CE 5602. The violators JT and Jordan Wakeland were issued a citation on April 10th, 2015 for the installation of new windows and construction of a wood deck and a storage room addition without code compliance from the city or permits from the Indian River County Building Department. Service of the citation was by return receipt on April 15th, 2015. Upon receipt of the citation, Mrs. Wakeland immediately contacted me and obtained a code compliance approval for the storage shed. A contractor was hired to obtain permits for the shed and the deck. The deck also still needs code compliance approval. Based upon the cooperation from Mrs. Wakeland and speaking with the contractor and the time that he would require, the case was pulled from the May Code Enforcement Board hearing. The civil penalty on the citation has been paid. The case is before the board today because I have not heard from the property owners or the contractors since the end of May and requesting the board issue a notice of assessment in this case for a daily penalty of $50 a day.
Are there any costs of prosecution? Or?
I'm not going to go for costs. They've tried to work with me. I just don't know why we've not followed through.
So you want $50 a day commencing when?
Sherry, can we go to they worked with me up until the end of May. Can it go to starting June 1?
Well,
Or does it go back to the compliance date on the citation?
compliance date on your citation,
April 15th.
was April 27th.
Correct.
So technically, it would typically start on the 28th, but the board can select another date if that's what you're asking.
I'm asking.
I will put that in the form of a motion that this be a continuing $50 a day assessment until it is rectified completely,
Starting June 1st?
Starting June 1.
starting June 1.
June 1.
Got a second?
Second.
All in favor?
Aye.
Sir, can you fill in all the blanks, sir?
I'm sorry?
Can you
Just-
fill in all the rest of the blanks? Or-
Yeah.
Just for clarification, there wasn't a compliance agreement, right? They just came in and got their code compliance for the work to get the building permit.
Correct.
Okay. But they didn't execute a compliance agreement.
No, sir.
Okay, thank you.
Okay. Case 15-CE-5708, Francis Jenkins, Tropical Auto Brokers, and William E. Iyer.
Requesting a notice of assessment for case 15 CE 5708. The violators, Francis Jenkins, Tropical Auto Brokers as the tenant, and William Iyer as the owner, were issued a warning citation on May 6, 2015 for site plan violation and not having a current business tax receipt. Receiving no contract from the tenant or the owner and the property not being brought into compliance, the citation was issued May 18, 2015. Service was by return receipt by both parties at separate addresses on May 21, 2015. No request for a hearing on the citation was received, so a hearing to contest the citation has been waived and the violation is deemed admitted by the violator. The violations have not been corrected as of July 8, 2015. The civil penalty has not been paid. Enforcement costs of $54.34 are requested. $54.35 are requested by the city with an affidavit of those costs on file with the clerk. Request the board issue a notice of assessment in this case for the civil penalty of $50, a daily penalty of $50 per day, and the cost of enforcement.
Hasn't this one been up before?
Yes. Isn't this a repeat?
No, you're thinking the one further north.
Oh. Thought they were all the same. Okay.
Oh, okay.
Okay. Anybody have a motion or?
$50 a day starting when?
526 compliance date was 525 on the citation.
I will put that in form of motion that the $50 a day commence on 5/26 with a $50 a day penalty in the course of enforcement, and also that fee of $34.35.
54.34.
Yeah,
54.35.
35, yeah.
54.35, what did I say? Okay, that's my motion.
I second
Do we
it.
have a second yet? All in favor?
Aye.
Motion carries. No way it's going to. Okay, 15-CE.
Mr. Chairman, not to interrupt you, but on each of these cases, we've got people in the audience. We probably should make sure that none of these people are here before we.
True.
On
What are you guys here for?
Oh, what I'm here for?
Yeah.
Which case?
Oh, I'm here, case, I'm here for a code, stop work order code violation, but I don't know what the case number is.
What's the name?
Fulcini,
It's not on today's agenda.
Oh,
it's today, yeah, July 8th at, 2:15, 2 o'clock.
you're not on my list.
Mr. Chairman,
What happened?
Mr. Chairman, that's a building department case. Mr. Fuccini had signed a citation. He signed both places requesting an appeal and accepting the citation. So we had asked him to send a letter in requesting an appeal of the citation. We never received that letter, so he was never put on the agenda.
Okay.
So that's the reason for that. I can meet with the Fuccini family after this and discuss the matter with them if they want to stay after the meeting.
Well, it looks like we might have some time to kill if
Well,
you
we
wanna-
can't hear that case.
Oh, we can't hear that?
I can't hear it now.
Well, David can talk to them, but
It doesn't say anything here about a letter, though, so I didn't know, otherwise I would have done that. I mean, on the citation, it just says to appear. It's not written that there's a letter that needs to be done, so. You guys can't do this today, right?
Sorry, I can only do what they tell me on here.
I know the rules, when they tell you to do something, you gotta do it.
Just we're not used to having spectators here, so.
Believe me, I don't want to spectate.
Well, I'd suggest you get together with the building department official after the meeting, and I'm sure he can help you get things straightened out.
Lady.
Ma'am, are you here for anything in particular, or?
No.
Okay.
It's my wife.
Oh,
okay.
nice to meet you.
Not him. Oh, no.
He's here to keep him straight.
Keep me in line.
He is on TV. You can watch him from home, too. Okay, now we'll move on. 15-CE-5670, City Mortgage and Cecil R. Bays.
Requesting a notice of assessment for case 15 CE 5670. The violators, Cecil Bays and City Mortgage, were issued a warning citation on April 20th, 2015 for weeds, grass, or undergrowth at a height of more than 12 inches and household garbage and debris throughout the property. The bank was also notified by email to the representative who handles the property. The bank advised by email April 27th, 2015 that an order was placed to their contractor to abate the violations. I received an email May 5th, 2015 from the bank requesting permission for the contractor to access the property based on the city securing the property by boarding the structure. The bank noted no trespassing signs on the structure and wanted access to the inside of the structure to place the household items, garbage, and debris inside. The bank was advised that the no trespassing signs were not placed by the city, no affidavit to enforce was ever filed, and the city had boarded the structure due to arson, transients occupying the house, and that we had no objections to the bank doing whatever they needed to do to clean up, mow, and maintain the property. After 13 days, the property was still not in compliance, so a citation was issued to both parties. Service of the citation was by posting for Mr. Bays and by return receipt for City Mortgage on May 22, 2015. The property was cleaned up and mowed on June 27, 2015, but the contractors left a large pile of debris curbside. The bank was notified via email that the code requires that our city code requires contractors to remove debris, and there are no utilities at the property, and solid waste will not pick up the debris. As of July 8, 2015, the property is still not in compliance, and the civil penalty remains unpaid. Request the board issue a notice of assessment in this case for the initial civil penalty of $50 and a daily penalty of $50 a day.
And your correction date was June 2nd, so you want it to start June 3rd?
Correct.
Is this to the bank? You dealing with a bank here?
A bank and a property owner.
So they both been issued?
Correct.
Well, this property is, I know, is in
obviously.
foreclosure, and it has not been resolved in the court system yet. So
They've already got running
So
fines
is
against
this
them,
a-
don't they?
I'm sorry?
They already have running fines against them, don't they?
They
think there was
have abatements against them where we've abated in the past.
there was abatement, and there may have been earlier fines.
Maybe earlier fines. There's at
It was
least
probably
two
abated by the
abatements.
city taking action.
Right. There's at least two abatements that the city has done.
So that, what you're saying is they're repeat offenders?
Oh, yeah, long time.
Okay.
Big time, long time.
Okay. Well, then, I will put that in the form of motion that as of June 3rd, 2015, we assess them $50 a day plus the cost of the assessments.
And the initial civil penalty.
And the initial civil penalty, exactly.
What was the cost?
50. Oh, the enforcement costs? No, I'm sorry, not enforcement costs, because they attempted to work with me.
Just the original
The original 50
civil
and the
penalty.
daily.
So no costs are requested.
Correct.
I second that motion.
All in favor?
Aye.
Aye. Motion carries. We'll move on to request for board order 15-C-5723, Leon DeThurston.
This was a notice of assessment we did last month. I'm asking that we rescind this notice of assessment. We had cited the wrong individual. The property appraiser's address and name was not up to date. It has since complied. So I'm wanting to rescind the original notice of assessment.
Okay, I'll make a motion that the board rescind the initial notice of assessment.
I'll second it.
All in favor?
Aye.
Motion carries. Case 14-CE-4953, Gregory Hassel.
This case has similar circumstances. A notice of assessment was issued last month. He has obtained a permit. He didn't understand what I was saying before, so he has come into compliance asking for the NOA to be rescinded.
Okay. I'll make a motion that we rescind this notice of assessment on this property. Second. All in favor?
Aye.
Motion carries.
Do you want to start this case?
I went slow and it's only... Can we start? They left, didn't they? Or
My intent was to pull it,
okay.
to work with them. It's a commercial property. The woman who's here is the property owner. The tenant installed a fence. In order to obtain a permit, a contractor has to pull the permit. So she was hoping that the tenant whose husband installed it would speak on their behalf.
I think they're right outside.
I think she's hoping the tenant comes.
Have you spoken with
It
the
sounds
tenant?
like your intent doesn't really
No,
require
'cause
any
my intent
discussion.
was to pull it to try to give us all time to work together, because the owner has done the code compliance, doing what she needs to do. It's just going to be a longer process due to a contractor needing to be involved.
Right.
Have you actually spoken with the tenant?
I have not.
Oh, okay.
Do you want me to
Why don't you?
start the case and then she can speak and we can give the tenant time?
Yeah.
What?
Or just go ahead and pull
No,
it.
if you don't,
Or we can
if
actually.
you don't need the board to take any action, there's no sense in you putting on any of the case.
She's asking for the board to hear her case, but I think in her best interest would be allow us time to all come together.
Sorry, because she had to call the restaurant 2:30 because she already do everything, but her husband doesn't work, don't help her anything.
The woman who is the tenant, whose husband installed the fence, owns the sandwich shop, and she is open until 2:30. So she's trying to finish her.
I understand. Yeah.
I live in West Palm Beach, and then people take
Oh,
care
you-
of my building, and
So you're trying to avoid coming back next month, huh?
Mr. Chairman, can we take a short recess? Is that permissible?
Or if Melody needs to work with them anyway, they're maybe just reschedule for next month.
I think everyone on the board would
Be
be
it resolved.
agreeable to just giving
pull
you
this.
another month and letting you work things out with the code enforcement officer.
I appreciate because since I didn't know that because I'm not live here, I live in West Palm, and I have my kid autistic last month, and my another kid and he a policeman here in the hospital in Miami. So I called the people here take care of the building. They said, don't worry, and everything clicked in my mind. Okay, they take care. Until I get a second notice, I said, what's going on? Oh, we get a survey. So I had to drive here, give them a survey.
Yeah.
And now the lady, and today I come here, and they told me just sign the old, I'm a signer and phone here, and they give you a permit. So when they come here, they said, no, you have to go to the building. When they go to the building, they said, oh, you need contractor.
Is this she?
Is this your tenant?
Right, let's see.
Wonderful.
Okay.
She worked so hard. She worked by herself, everything. Yeah. The reason she said.
Well, she
Okay,
needs
time
to
out.
be sworn in.
Okay.
I guess we'll go ahead and do this.
Sworn in.
Yeah, my husband didn't know.
Hey, get that. Turn your microphone back on.
The problem is the fence requires a permit. The contractor needs to sign off, but it needs the code. That was the problem. Yeah, that's a problem, but we don't have to exercise.
Right. See, the problem is that you would have to hire a contractor
we're asking today is just hold the case. We will not have the case heard. We will work with you to get what we need to have the fence permitted.
I have one question here. Sure. Usually this place, they have an old fence and the storm just turned it up, over 10 years. And she come here, she just bought the business for 2 years. So she tried to look everything nice, and that time the old fence, they try to pass, they put a new one. She doesn't know that they have a permit.
Yeah.
So she get all the workers here to fix, because half a fence, that look like a couple of wood there.
It's just like a partition fence to block like an ice machine and
Right,
stuff.
and isolation, you see the restaurant back there look like a, see the pot and pan, everything, and that's why. And she and her worker put it wood there.
But it's a commercial property, contractor has to pull permit.
Wow. So you're here for that.
License contract.
Any thoughts, David, from the building department?
We need to get this on. I mean, the speakers are not picking any of this up, so it's.
And,
Well, we're not hearing it as a case.
I mean, I thought they
Until
were just
they're
having a
sworn in, they're
discussion.
They're kind of
This
discussing
whole thing
internally
is-
while we watch.
Melody, have you discussed with them? I mean, is it just a little piece of fence, or? I mean, the other option is take the fence step back down, undo it,
I offered that. They don't want to take the fence down.
and then you have to go hire a contractor. You'd have to hire a fencing company to get the permit for you, and then they may want to redo the fence for you. I don't know, but because it's commercial property, they won't accept anybody but a licensed contractor to pull the permit.
Our contractor
correct.
investigator has a thought.
No.
Oh, I thought you did.
Mr. Clement covered it. They needed to get because it is commercial property, they can't pull a permit, so just hire a licensed fence contractor. They can come out there and pull an after-the-fact permit and take care of it for you.
Let's just reschedule this for next month.
I'll second that. All in favor?
Aye.
Yeah, you can put it away now. We're still not done.
What, you gonna take this one?
So we're still not done.
Oh, what was that other thing we had?
You got yours?
I'm sure that's exciting enough to keep you awake. Okay. Well, we'll move on to the attorney's matters, amendments to the code enforcement ordinance.
Okay. I just want to make sure the board, we had talked in the past about some amendments going to be made to the, that we were proposing to the city council about the code enforcement ordinance. The major thing that we're doing is that step that we were doing today, the notices of assessment, gone. What would happen is basically the same thing that happens under the state statute process, or like under a contracting citation. Instead of that notice of assessment step, the officers would be coming in and requesting a board order. And those would be, if we skip that step of the notice of assessment, you're going right to that board order that they come back when they still don't get compliance, that says that the board orders the violation corrected and sets a date for, if they don't correct it by a date the board gives, then fines start to accrue. So that speeds really everything up by a month. Plus, it eliminates that confusing step of notice of assessment being issued by the clerk. We originally got that process, if you remember, the ones of you were on the board at the time when this was adopted, I think back in 2008 or 9. We followed the Miami-Dade County ordinance where they opted out of Chapter 162 of the statutes. We chose that ordinance because it had been challenged a couple different times and been upheld by the courts as constitutional. So we use that as a model, but there's no real legal reason why we have to have that notice of assessment step. And like I said, it really kind of reverts to what you do under Chapter 162 if we were using those procedures anyway. So that speeds it up and gets us hopefully to compliance quicker and earlier and what have you. There are a few other miscellaneous things that we're doing. Just for some reason we had a slight, a little bit of a conflict between two sections of the ordinance, where one said that, and it probably originally came out of the language, probably out of our city code, where there had to be at least 4 affirmative votes to be official action of the board. But in another section, which is really the part that came from the ordinance we were copying, said that no vote was official unless 4 voted, not that it had to be all the same affirmative vote. And if you look back at Chapter 162, that's the process that's used in the state statute too. It's just so long as 4 vote, so even if it's like 3-1, it's still official action when you only have, say, 4, but there has to be at least 4 voting. So we fixed that conflict. We clarified that when there's a repeat violation, the officer doesn't have to give time for correction. That, again, is something that's in Chapter 162. It was kind of presumed with us, but I think in practice the officers were giving time anyway, even on repeats, but they don't have to. And that's pretty much following state law, the way that process works. So there was a lot of things removed that had to do with the notice of assessment. There was a clarification that these compliance agreements, the way it was written before, it was just basically a matter of right. An alleged violator could just say, hey, I want to do one of these compliance agreements. Well, what we did, we tweaked it so that now it's really in the discretion of the officer and the officer supervisor if the person or the violator fits into that niche where they believe that they're going to follow up. In other words, there's good reasons and there's some criteria that we put into the code. It's not automatic anymore under this. It's been amended so that they can be given the opportunity to participate in a compliance agreement, but it's not by right. It's only if they qualify pursuant to the criteria that they can participate in one of those agreements. If they don't then comply with that agreement, it still comes back to the board for enforcement. There was one of the sections had to do with the superiority of code enforcement liens. Well, the Florida Supreme Court resolved that issue. They said, no, your code enforcement liens are not superior, even if you have it in your ordinance. They're always trumped by anything. The way it works, if you look at the statute, and this is what the court said, that the statutes set out the priority of encumbrances and liens and things like that. Basically, it says whoever records first, they have priority. Another little twist to it, though, is purchase money mortgages always have priority, even if it was after the code enforcement lien. That's always going to have priority. And plus, you may or may not remember that code enforcement liens don't attach to homestead property anyway. So anyway, we're cleaning that up, just taking that provision out because it's unenforceable, according to the Florida Supreme Court.
Code enforcement, they don't put liens on homesteaded property?
They don't apply. They don't apply to homestead property. No. That's a constitutional thing, a Florida constitutional thing. It just says, sorry. And let's see. Also, assignment of liens. We had a provision in there, and there's unfortunately newer case law that says that code enforcement liens are one of those things that's a creature only of government, of municipalities. And they just say, sorry, you can't sell those and assign them to someone else to collect. We can use different collection methods, including collection agencies and what have you, but to sell them at a reduced amount and then they try and collect it that's really not permitted. And plus, as long as I've been here, we've never even tried to even looked at assigning a lien. It's just not a high value thing that you might get 10 cents on the dollar if you were to sell it, because the person buying it is taking the risk of whether or not they can collect anything. So we're eliminating that. And there was one other thing. I think the other thing was we were clarifying that when there is a request for an interpretation of the code that would basically intercedes, like the one case we had today, the first case, it's not really, we don't want it to be holding the entire case in abeyance, just want to postpone the hearing. And the reason this came up is because I've gotten a couple questions about, well, what happens, are these fines still running? Well, if you say it's in abeyance, you could argue it either way. So we just tried to clarify that no, all the board's doing is postponing the hearing. Nothing else is happening. That's it. So that it's more clear now that if and when it comes back after the administrative appeal of the interpretation, if in fact they've still been carrying on whatever it is they've been doing that's illegal, then they could still be fined for that entire period. At least that would be our hoped interpretation. But other than that, if you have some questions, if there's something else that you can think of that maybe we should amend, let me know.
I'm not clear. The first thing you covered, the 4 votes, the votes.
It just has to, we have to have 4 members present for a quorum.
Right.
So at least 4 of those 4 members have to vote. Even though we have more than 4 here today, if say there was some conflicts for some reason, you couldn't vote because the person in front of us was your wife, you wouldn't be able to vote. You wouldn't be able to vote. So in other words, if there's some reason, there has to be at least 4 voting, and a majority of those 4 has to vote for that action to be affirmative. The bad thing is, and this happens in state law too, if you have a vote of 2-2, it's basically considered then the motion fails for being able to be passed.
It doesn't have to be unanimous anymore.
No, we only have 4. And we've never followed that rule anyway since we adopted this ordinance, but I just happened to note in one section it said it had to be the affirmative vote. And I said that must have been a carryover over our old ordinance. So we made it comport with the state law, the way it worked, and the way we really always did it, because we used to be under the state law. Under Chapter 162. So we clarified that from when the ordinance was originally written. There was a little glitch there we just didn't catch. But we've always practiced it that way only. As long as 4 is voting, then, and there was a majority of the 4, then you have good action. You have an official action.
Okay, you referred to the first case we heard was the Wagners, and had an attorney here. Do they know that the fees are going to be going on while this was postponed?
I don't know. You have to ask them. I don't think the board or anybody else is under the obligation to tell them that. It's basically they want to take that appeal, and they think apparently that they have, reason to think that they can get a different interpretation other than what the officers use, and they have that right to appeal that. And remember now, they're required to exhaust those administrative remedies before they come back to the board. So,
We're not obligated to tell them the clock is running on your.
No.
I think I may have mentioned that in a question form at the last meeting.
Yes,
Is the
and
clock
that's
running?
and that was the second or third time I'd gotten the question. That's one reason we're clearing that up to say all the board is doing is postponing the hearing, not stopping the case from any further violation or anything.
It would seem to me that.
But remember, the officers, they still have to prove their case, so.
Well, what I was going to say is, it would seem to me it would be sometimes to their advantage to hear the case because maybe nothing's going to come of it instead of having this running clock.
That's true.
Take your chances, but try the case first.
That was my answer. They take their chances.
Well,
So it's
thank you.
running fees running every day plus an attorney. That's a good one.
Okay. We do have, besides this one case that you mentioned, we had other cases that were postponed.
There's two.
The clock is running on them also.
There's I think 3 other cases that had already requested administrative interpretation of the code.
Okay.
They're appealing the interpretation.
Okay, thank you.
Two other ones on the guest house vacation. Short-term rentals, basically.
Right.
And then there's one actually on a boarding house, on whether or not it's a boarding house. So, other than that, unless you have something else, that's it for me.
Thank you. We will adjourn.
Thank you, Howard.